In the last 20 years, mediation has become a very important resource to help couples go through divorce and custody matters. What happens in mediation, you may ask? Well, what happens in mediation is that parties can go to mediation by themselves or with their attorneys, and they'll sit down with a neutral. That neutral is the mediator. The mediator cannot make decisions for the parties, but what the mediator can do is help the parties reach a decision together. If a mediator helps parties reach a decision together, then the mediator writes up that decision. It can be for part of the divorce, it can be for the entire divorce. When they write up that document can then be sent to the judge to sign off on as an order. It can be a temporary order for a temporary mediation. It can be a final order for a divorce. Whatever's written up by the mediator will be agreed to between the parties, and many times cases can resolve in mediation without having to go through litigation. Mediation is a cooperative way to be able to resolve divorces and custody actions. And so we're proud to have worked with hundreds of clients to have their divorces resolved in mediation without having to go through the adversarial nature of litigation in a divorce. Because ultimately, when we as attorneys walk away, we want families to be able to still be families, and going through litigation many times hurts those chances. What are mediation pros and cons? One pro is that mediation can be done quickly in a divorce. Why? Because parties can decide to go to mediation early and sometimes often in a divorce. That can cause the parties to sit down and actually go through the issues they have and reach some type of agreement. The con. A con to a mediation is that sometimes you won't resolve the issue. What that means is that you can't be forced to come to an agreement in mediation. Mediation is a collaborative process, so if the mediator doesn't get both parties to agree, you don't have an agreement. A pro. Mediation can many times resolve your case without having to go through extensive litigation. If you resolve your case in mediation and the agreement is written up and filed with the court, your divorce or custody case could be over. If not, the con is you have to go through litigation. Georgia courts have started referring most, if not all, cases to mediation. Mediation can be a way to get your case resolved in a quick manner, but it requires collaboration of the parties. So tips that we often give for people going through mediation are these. Number one, make sure that you're getting along with the other party before you go into mediation. It's easier if parties are getting along to be able to resolve issues than if they're coming in upset with each other. Number two, make sure that you have all the documents that the parties will be talking about in their most current form. What do I mean by that? Bills, retirement accounts, assets, debts, etc. Make sure you have the most current documents so that they can be looked at by the parties to determine how they're going to be divided. The third thing I would say is make sure you have time and patience. Mediation can take a while. Sometimes people can be in mediation for 2 hours, sometimes they can be in mediation for 8 to 10 hours. So bring time and patience with you when you're coming to mediation. Following those 3 tips hopefully will help you have a successful mediation. If you have any questions about mediation, don't hesitate to give us a call. I'm a certified mediator here in the state of Georgia. I can help you in your mediation process.